Well, joining me here in the studio is my friend Mimi Rocah. She's a former assistant U.S. attorney for the SDNY and former Westchester County District Attorney. And you've been on this show a long time ago, so we would go way back. But anyway, I'm glad to have you here. All right, so at this hearing this week, the attorneys for Eric Adams and the DOJ, they denied there was any kind of a quid pro quo, right? They denied this. They said that they were just dropping the charges in exchange for delivering on Trump's immigration policies. That would be a quid pro quo, but they're saying, no, it wasn't that, but that's what the expectations are. Give me a sense of the judge's justification for delaying the trial and the questions the judge wants to be answered by this independent, conservative legal advisor.
Yeah, so the way I would think about this, Alex, is essentially the DOJ, Emil Bove, who's a acting deputy attorney general, went in and he and Adams, Mayor Eric Adams, and his lawyers said, take our word for it that there was no quid pro quo.
We're telling you. Sounds.
Yeah, and despite what I said in my letter to acting U.S. Attorney Danielle Sassoon, you can't take that into account. He actually said that. And he said, even if there was a quid pro quo, you, Judge, don't really have any authority to deny this. All of that, I'll just say for now, I disagree with. The judge didn't really push back much at the hearing, but clearly he took that in and is saying, wait a minute. You know, there's a lot of smoke here, right? There are these letters where Emil Bove said things that are now he's trying to contradict and walk back. He did say in those letters, the only reason we're telling you to dismiss this is we want Eric Adams to be able to do his job and enforce the immigration laws the way we want him to. Eric Adams went on TV the next day and basically, you know, sort of laughed about this quid pro quo. So the judge doesn't need to find a quid pro quo here to say that this is inappropriate. Part of what he's asking this independent counsel, Paul Clemente, former Solicitor General under Bush,
conservative,
very conservative, but a law person, right?
Yeah.
A person who will follow the rule of law. I don't think he's being appointed to find one thing or the other, but rather to help the judge answer very complex questions in a very unique scenario. What is the standard for the judge? What does he need to find? Should he have a hearing? Can he take into account those other letters and statements by Bove and others in the administration? All of that is really consequential and complicated.
It sounds legally, though, just because Emil Bove says don't take this into account, legally, does he have a leg on which to stand to make that claim?
I was surprised when he said that because judges take judicial notice of things all the time. I mean, I've been in front of judges where they say, I'm going to take judicial notice of the fact that it's sunny outside. I mean, they can literally take judicial notice of almost anything. I think the judge, part of why, and one of the explicit questions he asked this new counsel, Clemente, to look at is, what can I take into account? And I think on that question, we will see that he will be able to take more into account. I mean, one extreme version would be getting other people like Danielle Sassoon to come in and testify. I don't think he's going to do that, but there's a lot that is sort of in the public record that the judge could consider in his ultimate decision and ruling.
Here's kind of an interesting turn of events because you had yesterday Mayor Adams suing the Trump administration. This was to return the $80 million that disappeared from the New York City coffers overnight. That happened last week. It was a Biden-era payment for sheltering migrants, in different hotels and elsewhere throughout the city, right? So in this court filing, the city says removing the money was lawless. Was it lawless?
Yes, I think it was.
They may just take it back.
Right. I mean, it's a clawback, right? But this gets to the heart of two issues, right? One is the Trump administration over and over taking money that was appropriated or by Congress and by the prior administration and just saying, we're going to undo that. And it's not that they can't make policy choices. Of course they can. But it's the process and whether it is lawful and constitutional or not, the way they're doing it here and in other cases. And then the second theme that I think is important here is the administration's attempted use at leverage, right? Saying if you don't comply with certain things that we want, we're going to either use the criminal process, that's what we're seeing with Adams, we're going to hold that over your head, or we're going to take funds back from you. And I think Adams is trying to say, look, I don't have anything hanging over my head. I'm suing the Trump administration. I don't know that he had much choice, but I do think he's trying to use that to show his independence.
Let's get to the major setback in Trump's DEI order that a federal judge yesterday blocked the administration from terminating federal grants and contracts for diversity, equity, and inclusion initiatives. Why did the judge rule Trump's orders likely violate the First Amendment? What happens next in the case?
So the judge had two bases for his ruling, several, but two main bases. One is that it was an unconstitutionally vague order, right? If you're going to tell someone you can or can't do something, you, the government, you have to be clear in your directives. Just saying all DEI programs must be stopped. And
so you have to give reason for it?
You have to give clear guidelines. What is a DEI program? Like what, you know, and so the judge said this is too vague. How could any school or administrator comply with this? The other thing he said, and this gets back to our theme we were talking about a minute ago about coercion using the criminal justice system, is that it would impede First Amendment rights because the order required people in government to sort of report on colleagues who still might be trying to enforce or continue DEI efforts. And the threat was literally, we will come after you with, I think, criminal charges. And that is threatening someone with criminal charges. Again, that's a theme we're seeing here, this corruption of the criminal justice system. I'm not even going to use the word weaponization because it's kind of beyond that. It's a corruption of the criminal justice system that they keep trying to use to exert leverage. And the judge said, you can't do that here in the context of the First Amendment. So this is a preliminary ruling. There will be more on the merits to play out, sure. As with many of these rulings. But, you know, I think we're seeing that the courts are slowing down what they're trying to do. And again, it's not about policy choices. It's about the process and the procedure.
Okay. Well, since there's more to come, we'll see you again, Mimi Rocah. Thank you so much.